If the decision is ruled that the bankruptcy court is not the right place to resolve these difficulties in the Purdue case, how profound a ruling will that be in terms of the analog to the case you're talking about in Georgia Pacific and other cases? Do you think that will eliminate this as a tactic for companies?
Unfortunately, what these companies have recognized, I believe, over the last 5 years, Georgia Pacific filed the first one of these manipulative bankruptcies about 5 years ago. And I think what the companies have realized is that the longer these cases are dragged out, the more they benefit, whether they eventually win or not. If the Supreme Court says that the Sacklers can't get relief through Purdue's bankruptcy, that's another nail in the coffin for this manipulation of the bankruptcy code. But will it end it? Unfortunately, when companies have billions and billions of dollars to spend on lawyers, and they're not afraid of the consequences of having their cases dismissed as being bad faith filings, we can only hope that they'll abide by the law.
So let me ask about the next steps for you. Since I saw there was recently another rejection of this tactic, if that's the right way to put it, for the Johnson & Johnson subsidiary, is this just going to keep happening of filing and refiling? Where do you get resolution for your client and for others that have claims against the company?
Well, hopefully Johnson & Johnson will abide by the ruling of the Third Circuit and the ruling of Judge Kaplan dismissing the second attempt, and they'll return to the tort system and they'll litigate these cases and resolve them, which they were doing before they filed the first fake bankruptcy. They resolved over 7,000 claims, cancer claims, before they filed the first bankruptcy over the course of less than 2 years. There's no reason why they can't efficiently and effectively manage this liability in the court system like they were doing before they filed. And I hope they'll do that. I hope they'll follow the letter of the law and the spirit of the law. I'm not optimistic because of the way it happened last time, but I'm hopeful. And on behalf of my clients, I've moved to dismiss the Georgia Pacific bankruptcy and another 2 bankruptcies that are pending in North Carolina, and hopefully we'll have some resolution on that from the Fourth Circuit Court of Appeals soon as well.
Let me ask one other question, which is more from a legal expertise point of view, which is you have expertise in terms of these sort of mass tort cases. Bankruptcy is a very different process. I would imagine it takes a different type of legal expertise to be navigating the bankruptcy system versus the tort system. Am I right about that? And I'm curious, if it's bringing in a new type of lawyer or who you work with when something is going through bankruptcy court as opposed to the usual system.
Sure, there certainly are lawyers that specialize in bankruptcy law. Amusingly, in a blast from the past kind of thing, I started my career off as a lawyer, as a creditor's rights lawyer, but 25 years ago started representing cancer victims full time. So for me, it's sort of like going home again. But there are different skill sets, but the law is the law, and justice is justice. And I believe in this system. And I think the courts more often than not get it right and get it right eventually. And I'm confident that the Supreme Court's going to see through this. There are lots of skilled lawyers, both bankruptcy lawyers and trial lawyers like myself that have been working on this. And the courts, I think, are going to get it right more often than not. And I think what that'll do is put an end to this, because the bankruptcy court isn't a menu choice for the super wealthy. There's no reason why Koch Industries should be getting relief in bankruptcy. They're not bankrupt.
Well, I certainly think those arguments will play out before the Supreme Court. Jon Ruckdeschel, thank you for joining us, and I look forward to continuing the conversation.